Okay, we're back in session. Mr. Szolek, you may proceed.
Mr. Chairman, members of the board, my name is Fred Wszolek. I'm spokesperson for the Workforce Fairness Institute. Thanks for the opportunity to address the board on that portion of the proposed election rule that would extend the board's Excelsior list requirements to include disclosure of an employee's telephone numbers and, where available, email addresses to the union seeking to organize them. We're opposed. We believe that an employee's personal contact information, whether it be a home or email address, should not be disclosed to third parties absent the employee's consent. In his famous dissent in the 1928 case Olmsted v. United States, Justice Louis Brandeis said, "The right to be left alone is the most comprehensive of rights, the right most valued by civilized men." Today, Brandeis' view is the law, and the right to be left alone, the right to privacy, is recognized as an essential component of our liberty. It protects our individuality, allows us to exercise control over information about ourselves, and to make decisions free from coercion. There is no express right to privacy in the Constitution. Its contemporary contours largely developed in American law over the past half-century. In addition to important Supreme Court jurisprudence, as privacy has become increasingly threatened by new technologies and business methodologies, a variety of state and federal laws have been passed protecting individuals from unwanted disclosure of personal information. The board's proposal is inconsistent with these developments in the law. It improperly invades private space and is contrary to the reasonable expectations of today's workers. An employee's personal contact information is provided to the employer with the expectation that it will be kept private and used by the employer in the event of emergency or when circumstances require that the employee be contacted outside of work hours, and of course to send you the delightful tax document at the end of the year. If the board wishes to modernize its rules in this area, it should do so in a manner consistent with our society's contemporary concern for individual privacy. That means putting the worker in control and not releasing any personal contact information absent his or her prior consent. In the board's Excelsior underwear decision, the employer mailed an 8-page letter to employees that allegedly made misstatements about the union and contained threats of retaliation. It then refused to give the union a mailing list of employees to enable the union to counter what it said. It was under those circumstances that the board adopted the current Excelsior requirements to remove an impediment to communication and to allow for a more fully formed and reasonable choice. While disclosure of an eligibility list with home addresses may have been necessary 50 years ago under the facts in that case, disclosure of personal contact information such as being proposed is wholly unnecessary today. Today, if an employer communicates with his employees on the issue of unionization, it will likely be via email or the internet or at a mandatory meeting. The contents of these communications will become readily known to the union, which can counter them on its own website or blog, all of which are easily accessible, or by contacting employees by the manner they have consented to. Let me add, picketing, even the threat to picket, is inherently coercive because of the history of violence surrounding it. Today, contemporary media, with its 24-hour news cycle, is saturated with stories of union intimidation and violence. I submitted an exhibit, which I respectfully request be made part of the hearing record, catalogs a very small bit of it. It supports the conclusion that the existing rule forcing the disclosure of employees' home addresses without their consent is intimidating, if not coercive, and that the proposal for expanding the disclosure of personal contact information is ill-considered. Thank you.
Do you want us to overrule Wyman Gordon?
No, my understanding is that the court gave you the discretion as to what information is prudent to share, and now you could choose to decide that it's prudent to no longer share home addresses.
Okay, but the court seemed to give the lend its imprimatur to that policy, and what do you think has changed since then?
I think all of our desire to protect our personal privacy has grown dramatically in the last 50 years, and the idea that someone can come knocking on your door anytime they want without your permission, without being invited, to pressure you into consenting to unionization is just not the way we feel things should be these days.
Okay, well, is there a Supreme Court case other than the FLRA case, which dealt with the Privacy Act FOIA interplay on home addresses, which obviously was federal workers, which we don't regulate? Is there some Supreme Court precedent that you're basing this on?
No, I'm just basing the trend toward us wanting to control more of our personal contact information, to control our privacy, and to avoid identity theft. There's just a whole range of reasons why we want more control rather than less these days.
Okay.
Would this right to be left alone, would this contact restriction that you're that you're proposing apply both as to communications about the campaign from any party?
Well, I suppose if you're in the workplace and the employer wants to communicate with you about the company, that I'm not sure you can necessarily opt out of that. But there's been great debate over whether people can opt out of releasing their email address, which is an electronic address that doesn't exist in the real world, yet we seem to just accept as an absolute given that being told where you live is fair game.
So you're saying it would apply to employer contacts through email or through home address?
I suppose it could, but as you know, the Excelsior decision involved a mailing to people's homes. Companies just really don't do that anymore. They've got so many other methods of communicating with their workers that they don't need to mail 8-page letters to people's homes. They can communicate in the workplace.
Well, isn't that the point? If the companies are not communicating by mail, then the union should be able to communicate the way the companies can, don't you think? We heard testimony about robust debate and discourse as part of free speech and those kind of opportunities being protected. Wouldn't that be counter to that notion?
If the employee consents to the release of his home address, and perhaps he could consent to whether he wants to have that just be for mailing purposes or to be actually visited, they should have control over that and open the door or close the door.
Well, membership asked, would that apply to the employer? Should the employee be able to opt out of the employer sending them information or their position on unions or anti-union messages?
I don't think we would object to applying the same stricture to mailing from the company or the company coming and visiting you at home. That's your home.
What about emails?
If the employee consents to the release of his email address for those reasons, that's certainly useful.
So you're saying that the employee should have the right to opt out of getting that information via email from the employer as well?
Perhaps from his personal email address. If it's the company email address, I don't think the employee can control the flow of content from the company's email account.
I see. And if the union wants to communicate with the employee in the company's email account so that it's on have the same access as the company, do you have a problem with that?
I don't think I think there's a property issue there that the company need not necessarily turn over their digital property to the union.
Okay. All right. Thank you very much.
Thank you.
Safe flight.
Have a safe flight. Thanks.
Mr. Hogan.
Thank you very much. Aloysius Hogan, Senior Fellow with the Competitive Enterprise Institute, DC Free Market Think Tank. My colleague Trey Kovacs points out some of the unintended consequences that could arise from the board's proposed rule. Particular concern are privacy. And I want to run through for something you all are more familiar with, but for people who may be watching or reading ultimately, the Fisher versus Communication Workers of America, some of that displays some of the inconsistencies in determining when the federal labor law preempts state law. The case involves the Communication Worker of America, local in North Carolina, where its union president, John Glenn, posted in a public area at the company's North Carolina facility the names and social security numbers of AT&T employees who chose to rescind their union membership. At first, the AT&T employees filed an unfair labor practice, ULP with the NLRB, with you all, claiming that their NLRA Section 7 rights were violated by being coerced into exercising employees' right to self-organization. The NLRA protects every worker's right to refrain from exercising their Section 7 rights. Former General Counsel Leif Solomon refused to prosecute the CWA for posting and disseminating the AT&T employees' Social Security numbers. But the CWA and NLRB agreed to a voluntary settlement where CWA admitted no wrongdoing. After that, the employees with legal assistance from National Right to Work, they Foundation filed a lawsuit in North Carolina under its Identity Theft Protection Act. The trial court and North Carolina Court of Appeals found that the unions are entitled to a special exemption from being penalized for revealing employees' personal information. Both North Carolina courts ruled that unions may put employees at risk of identity theft because the activity is covered by the NLRA and consequently may not be punished by state authorities. North Carolina's courts have held that the federal labor law preempts state identity theft law, even though it is arguably unrelated to national labor policy and involves deep-rooted local interests. Our concern, Competitive Enterprise Institute's concern, is that the new rule, which would supply unions with employees' phone numbers, could put employees more at risk. You run into some of the same concerns with the Freedom from Union Violence Act that's been proposed to make up for the divot, let's say, that was taken out of the Hobbs Act with the Edmunds case in terms of union violence and extortion. You're running into some of the same issues here with the remedies that people would have when they face forms of coercion, extortion, violence at the hands of unions. And there's a problem between lack of federal enforcement if the General Counsel doesn't move forward on something in a way that the workers find useful, if the states won't move forward, if there's federal exemptions judicially created, and if, as has been previously mentioned, the legislators are not moving forward with correcting some of this, it causes a problem. I want to move to another quick point that, as I mentioned earlier, I analogized to Labor Management Reporting and Disclosure Act 1959 and suggested that that provides a ready structure for elections in the union context. The guide for election officials regarding conducting local union officer elections provides reference. Chapter 7, Inspecting the Membership List, states, quote, candidates in union officer elections also have a right to inspect a list of members and their addresses subject to a collective bargaining agreement, which requires union membership as a condition of employment. This right to inspect is limited to once within 30 days before the election and does not include the right to copy the list. I want to take up the last few seconds here to point out that an opt-in avoids some of the problems that of undeliverability and flagging and a degraded score that had been mentioned earlier. And really it comes down to freedom and people's liberties. And I might go to a bar tonight and give my email address to somebody, but that's a free choice. When the government gets in between and starts mandating, that's what people don't like, whether it's the government getting in between the student and the university, or it's the government getting in between the employee and the employer, or the government getting in between the doctor and the patient, as it were. That's where the line is drawn, when it's the government coercion versus, for example, an association which could fight for your, improving your situation in whatever association it may be. And they have lobbyists and they push for things, and you freely associate with them. You may pay the dues, join a couple associations, but when the government is mandating stuff, that's where the dividing line is. So.
Hey, I understand.
Well, first of all, this NPRM doesn't propose the disclosure of Social Security numbers.
Yeah, that's exactly right. But
Right.
that was obviously at issue in the Fisher case.
And do you have an idea as to how many union coercion cases there are versus the number of employer threat and unfair labor practices case sent out via email and text?
I don't have a statistic on that. I know where you're going with that. I don't have a statistic on that, though.
Okay.
I understand the state action point, your last point, and obviously we're a federal agency, so if we establish rules, it's going to be state action. Going back to the first point, is what you're saying basically, if we jump into this area, we are going to have to construct a remedy, because otherwise, because of Garmin preemption or machinist preemption, no state court is going to be able to follow up with, or state law could be an effective remedy.
That's exactly the point. You're exactly right.
Okay.
Thank you very much.